Hi, I'm Janice Switlo, and today is part 26 of my book, Cede 2.0, regarding the First Nation Land Management Act regime. I discuss allodial title in my book, Gustafson Lake Under Siege. Allodial ownership is a form of ownership that meant the landowner owed no feudal duties to any other person. An allode could be inherited freely according to the usual law of the land. One of the biggest advantages of having an allode is that the income from allodial estates was not liable for taxes paid to territorial princes, who could be secular or ecclesiastical. The no taxes payable on reserve thing is not the result of a Canadian tax exemption, which would mean the Crown has the jurisdiction to tax on reserve but decides not to exercise it. Rather, there are two bases for the Crown being unable to tax on reserve. Crown having no jurisdiction to tax on reserve. One, reserves are not part of the Indigenous nations' lands for which permissions are granted to the Crown by treaties. And two, as such, under her own law, the Crown must see these lands as allodial lands with underlying title, thus remaining in the Indigenous nations. And of course, even with treaties in place, where she does have permissions granted by treaty, it's important to understand that underlying title does still remain in the Indigenous nations. This is an insert I'm just providing now that I ought to have perhaps included here at the time. Crown governments ever since have been trying to buy the freehold or underlying title through enfranchisement processes and through amending the treaties by authentic interpretation. Quote, enfranchisement is a legal process for terminating a person's Indian status and conferring full Canadian citizenship. Enfranchisement was a key feature of the Canadian federal government's assimilation policies regarding Aboriginal peoples. Voluntary enfranchisement was introduced in the Gradual Civilization Act of 1857 and was based on the assumption that Aboriginal people would be willing to surrender their legal and ancestral identities for the privilege of gaining full Canadian citizenship and assimilating into Canadian society. Individuals or entire bands could enfranchise. In the case where a man with a family enfranchised, his wife and children would automatically be enfranchised. However, very few Aboriginal people or groups were willing to abandon their cultural and legal identities as anticipated by the colonial authorities. Enfranchisement would become legally compulsory with the Indian Act of 1876. Over time, Aboriginal people have been enfranchised for serving in the Canadian Armed Forces, gaining a university education, for leaving reserves for long periods, for instance, for employment, and for Aboriginal women if they married non-Indian men or if their Indian husbands died or abandoned them. Two major amendments to the Indian Act in 1951 and 1985 have significantly revised those portions of the Indian Act that relate to Indian status and, by extension, to the process of enfranchisement. That was a quote from Carmen Cray, Enfranchisement, Indigenous Foundation, First Nations Study Program, University of British Columbia. The whole enfranchisement thing was and is really about getting the land. The following is a summary of the federal legislation on enfranchisement. Another important statute was an act to encourage the gradual civilization of Indian tribes in this province and to amend the laws relating to Indians passed by the Province of Canada in 1857. Commonly referred to as the Gradual Civilization Act, this statute was the first to introduce the concept of enfranchisement, or the process by which Aboriginals lost their Indian status and became full British subjects. In introducing the Act, the colonial government viewed enfranchisement as a privilege for Aboriginals by which they could gain their freedom from the protected Indian status and gain the rights of full colonial citizenship, such as the right to vote. It is at this point that the strategies of civilization and assimilation begin their legislative existence, with colonial authorities encouraging Aboriginals to forego their Indian status and be drawn into the larger colonial society as regular citizens and hence become civilized. Under the Act, only Aboriginal men could seek enfranchisement. In order to do so, they had to be over the age of 21, able to read and write in either English or French, be reasonably well educated, free of debt, and of good moral character as determined by a commission of non-Aboriginal examiners. This is from the report of the Royal Commission on Aboriginal Peoples, 1996. Once enfranchised, the person was entitled to receive up to 50 acres of land from the reserve on which they lived and a per capita share of treaty annuities and other band monies. Enfranchisement was to be fully voluntary by the man seeking it. However, an enfranchised man's wife and children automatically lost their Indian status, regardless of whether or not they so desired. Now, I just add a note, personal note here, that, of course, when a person leaves a nation, they don't take any of the nation's land with them. There was no authority for Canadian governments to hive off pieces of reserves to give to those individuals who had chosen to enfranchise. So there's a whole lot of, well, not necessarily a whole lot, because not too many people did avail themselves of enfranchisement options. But those who did, there could be parcels of land out there that really don't have any lawful or legal title to which, under the Crown Canadian law, there can be a right to use. In 1860, the province of Canada passed the Indian Lands Act. An important element of this act was the centralization of control over Aboriginal affairs for the colony. The act created the office of the Chief Superintendent of Indian Affairs and transferred all authority for Aboriginals and their lands in the province of Canada to this single official. Moreover, the Chief Superintendent was given very broad discretionary powers over reserve Aboriginals. This centralization continued in 1867 when the province of Canada was united with Nova Scotia and New Brunswick to create the new nation of the Dominion of Canada. Section 91, sub 24 of the Constitution Act 1867 gave legislative authority in relation to 24 Indians and lands reserved for the Indians. In 1869, the Government of Canada passed an act for the gradual enfranchisement of Indians, the better management of Indian affairs, and to extend the provisions of the Act 31st Victoria. This act is significant in that it was the first to introduce the notion of self-government for Aboriginals on reserves. Under the Act, Aboriginal tribes or bands were permitted to elect chiefs and band councils for the purpose of general administration on reserves. These elected officials were granted limited bylaw powers and were elected to terms of 3 years. It is important to note many Aboriginal groups did not engage in democratic practices at the time. Consequently, the Act granted the government the power to impose democratic institutions on them, regardless of what Aboriginal groups desired. Furthermore, Aboriginal women were excluded from voting for band chiefs and councils. Women in general were excluded from voting at this time, as women's suffrage was not achieved in Canada until the early 1990s. This is continuing with this quote. In addition to a mechanism for Aboriginal self-government, the 1869 Act included other key provisions. It prohibited the sale of alcohol to Aboriginals on the paternalistic grounds of protecting Aboriginals from themselves. Furthermore, the Act instituted a compulsory enfranchisement provision. Under the Gradual Civilization Act, see above, enfranchisement was a completely voluntary process by which Indian status could only be lost at an individual's choosing. Under the 1869 Act, however, Aboriginal women who married non-Aboriginal men automatically lost their Indian status, regardless of whether or not they desired it. Moreover, any children resulting from the marriage would also be denied Indian status. This provision continued with the strategy of assimilation, as many Aboriginal women and their children forcefully lost their Indian status and gained Canadian citizenship. Overview of the First Indian Act, passed in 1876. The First Indian Act maintained the Crown's role as trustee of Aboriginal interests, but had a very different view of that relationship. No longer were Aboriginal groups viewed as autonomous quasi-nations within the broader Canadian politic system, to which the Crown had an obligation to protect from abuse and encroachment from European colonial society. Now remember, these are not my words. I'm reading from J. Makarenko, The Indian Act, Historical Overview, Judicial System and Legal Issues, 2008. And I have been for some time now. So continuing with that quote, the Act also maintained and broadened the system of enfranchisement by which Aboriginals could lose their Indian status and gain full citizenship. Previously, Aboriginals could voluntarily apply for enfranchisement if they met certain criteria. Moreover, compulsory enfranchisement occurred for Aboriginal women when they married non-Aboriginal men. In addition to maintaining these provisions, the Act allowed for the compulsory enfranchisement of any Aboriginal who received a university degree or who became a doctor, lawyer, or clergyman, regardless of whether they desired to lose their Indian status and gain full citizenship. Regarding self-government, the Act continued the system of elected chiefs and band councils who served for 3 years and had limited bylaw powers. As before, the Act granted the Superintendent General the power to impose democratic systems on Aboriginal groups, regardless of whether they were desired. Moreover, the Act allowed the Superintendent General to order a reserve to be surveyed and divided into lots, and then require band members to obtain tickets for individual plots of land. This allowed the government to promote individualism amongst Aboriginals by breaking up communal use of reserve lands and encouraging practices of individual ownership of property. Now again, I'm quoting, I don't agree any of this was lawful. Continuing with the quote, the practice of enfranchisement was kept in the 1951 Indian Act. Voluntary enfranchisement was still permitted, as well as the compulsory enfranchisement of Aboriginal women who married non-Aboriginal men was continued, and Aboriginals who received a university degree or who became a doctor, lawyer, or clergyman. Moreover, the 1951 Act introduced the double mother rule, which provided for the compulsory enfranchisement of persons whose mother and grandmother had obtained Indian status only through marriage to a man with status. However, under the new Act, the minister could only enfranchise an individual or band upon the advice of a special committee established for that purpose. One of the more important reforms concerned the application of provincial law to Aboriginals. Previously, the federal government had asserted exclusive jurisdiction to legislate in the context of Aboriginals. Changes made in 1951, however, provided that whenever a provincial law dealt with a subject not covered under the Indian Act, such as child welfare matters, Parliament would allow that provincial law to apply to Aboriginals on reserves. This opened the door to provincial participation in Aboriginal lawmaking. Again, that's all of the above was a quote from J. Makarenko, The Indian Act, Historical Overview, Judicial System and Legal Issues, published June 2, 2008. Captain Richard H. Pratt's recommended preached strategy against colonizing Indians in favor of individualizing them was and continues to be well followed in Canada. Note how the above summary fails to point out how the legislation could not effect what it purported to. Just because a law is written does not make it lawful and constitutional. It has been an exercise in attempting to rewrite and amend the treaties and thereby change the historical record, removing Indigenous nations, the treaties, and the very humanity of Indigenous nationals in the process. This acceptance that Indigenous nationals had no governance, that it was created by the federal government, is complete nonsense and complete systemic racism. That academics and reporters can still be repeating such nonsense and racist language reveals just how embedded and pervasive the systemic racism is. Building opt-in initiatives on such a foundation is foolhardy and not any exercise of nation rebuilding or any exercise of continuing jurisdiction. The residential school settlement and apology has not served to correct this foundation, but rather has reinforced it. It is what happens when money is the focus and the children do not matter, but were merely the instrument of conversion, of plunder. My heart goes out to Joanne Nahani, who on May 5, 2015, painfully found this out. She was abused in residential school she attended for 9 years. A formidable woman, a true survivor. She shared that the decision maker in her IAP hearing, independent assessment process, and my lawyer missed the opportunity, missed the chance to recognize what had happened to us at Indian residential school. I spoke my truth, told what happened, and told what it has taken for me to heal and feel that was not the purported reason for the hearing. A more than 2-year process to come to understand that this was not about justice and healing for her, but rather about something else entirely, is a harsh reality, yet she remains so inspirational. I have done all I can, she said. I am tired now, time to gather more strength. So she got 2 new tattoos. The first is a warrior chief, the head of a chief in a war bonnet. The other is, quote, end of the trail, end of quote, depicting a person carrying a staff on a horse, both exhausted, deeply conveying, completely done after a long, hard journey. Joanne explains that it is a long trail to get the healing and that you need to be a warrior. You are a chief of your own life.